a few hours, the Supreme Court's going to hear arguments in a case that could have a big impact on this race. Justices will decide whether Donald Trump can be removed from Colorado's ballot for his role in the insurrection on January 6th. Back in December, Colorado's state Supreme Court ruled Trump should not be on that state's ballot based on Section 3 of the 14th Amendment to the United States Constitution. Voters in more than 30 states have challenged Trump's eligibility, but so far only Colorado and Maine decided to remove Trump from the ballot. Joining us now, retired Judge J. Michael Luttig, who served on the United States Court of Appeals for the Fourth Circuit, President and CEO of the National Constitution Center and professor of law at the George Washington Law School, Jeffrey Rosen. He's also a contributing writer at The Atlantic. Good morning, guys. Judge Luttig, I'll start with you. What is your sense of what we're going to see at 10 o'clock this morning as those oral arguments begin at the Supreme Court? Would you expect the Supreme Court to be receptive to the idea that Donald Trump should be kept off the ballot?
Good morning, and thank you for having us with you this morning. The argument today will be historic. This case is probably the most historic constitutional and political case in all of American history. Section 3 of the 14th Amendment is the safety net, the Constitution's safety net for American democracy. And it's as if the framers of Section 3 foresaw January 6, 2021, and they provided in Section 3 that America would never experience another January 6. If Section 3 doesn't disqualify the former president, then, in my view, it would not disqualify any person at all. That is to say that the Supreme Court finds itself in a very precarious position today. Undoubtedly, it doesn't want to decide this case, and it will be looking for all legitimate off-ramps to decide that the former president is disqualified, but there are no legitimate off-ramps to that decision. So I think what you'll see this morning at the court is the court plumbing all possibilities with counsel as to how the court can resolve the case without deciding whether the former president is disqualified.
So the interesting thing is, especially Judge Luttig, the no legitimate off-ramps. I'm wondering if you can explain that. In your view, why there are no legitimate off-ramps for the Supreme Court? Because a lot of people have said, oh, they will keep Trump on the ballot because they don't want the public to lose confidence in the court. They don't want the Supreme Court, again, interfering in elections. It'll make people uncomfortable. Is that what this is about? Or is it about whether or not Donald Trump engaged in insurrection and then sort of gave safety and comfort to those who participated in the insurrection alongside with him?
It's the latter. Section 3 disqualifies any person who engaged in an insurrection or rebellion against the Constitution of the United States, having previously taken an oath to support the Constitution. There's no question whatsoever that the former president engaged in an insurrection against the Constitution when he attempted to remain in power beyond his constitutional term of 4 years and denied President Joe Biden the powers of the presidency to which he was entitled, having won the election by a vote of the American people. And all of this prevented the peaceful transfer of power for the first time in American history. This is precisely the insurrection that disqualifies one under Section 3 of the 14th Amendment. So you're right. That is the only legal issue. But there's such massive political consequences that although the Supreme Court ought not consider those, undoubtedly they will consider them. But the Constitution requires the disqualification of the former president.
So, Jeffrey, let's remind people, because there's been all this muddling over the last couple of years about what an insurrection is and isn't. It is a violent uprising against a government or an authority. That's the dictionary definition. Replay January 6th in your mind and ask yourself what that was. So I would put the question to you that we were discussing earlier with Barbara McQuade, which is, this is a constitutional question. It is the job of the Supreme Court to interpret the Constitution, obviously, to do this on the law. Do they consider, though, in your assessment, the implications of a decision that would keep Donald Trump off of ballot? That is to say, a large group of Americans saying our right to vote for the candidate for whom we want to vote is being taken away by the Supreme Court.
The court wouldn't explicitly consider the political reaction to the decision, but it might decide that the issue is a political question, that it's up to other branches to decide, like Congress when it counts the electoral vote. And that also suggests what some of the other off-ramps might look like. The court might decide that the president is not an officer of the United States, and therefore he's not covered by Section 3. You stated the definition of insurrection, but it might hold otherwise, that January 6th was a riot, not an insurrection, or that the president didn't engage in it when he called on people to march on the Mall. And then finally, there's this really big question about whether states can enforce the amendment on their own or whether Congress has to pass a law before the amendment can be enforced. All of these off-ramps, as the judge so well said, are available to the court if they want to avoid a definitive ruling. And in the oral argument, we should listen closely to see who's sympathetic to which of these off-ramps.